Okay, we need to have us on the TV.
Stop. There we go.
Good morning and welcome to the morning report. Today is Wednesday, July 5th, 2017. We're transmitting live from the Media Center in Harwington, Connecticut. And to my right, your left, is Attorney Rachel Baird. My name is Ed Peruta, and we're coming back from a holiday weekend and dog parks and dog blue ribbons and cannon fire and stringer requests and everything else that goes on a holiday weekend.
Well, good morning, Ed. It was a busy.
No.
I mean, busy in a good way, though. Busy in doing kind of fun things. I mean, I went up to the Litchfield Town Green yesterday for a pet parade. There were over 50 dogs there. It was amazing, and every dog got an award, which, you know, I know in these modern times people complain about their, you know, children's events or children's competitions, and everybody has to get an award, everybody has to get a medal, everybody has to get a, what are those called? Statue? Trophy. Okay, but in the case of dogs, I think it was fine. But it did take a while for 50 dog owners and their dogs to stand around getting awards. And there was one little girl that brought a stuffed animal, cat, and even she got an award. Now, I may draw the line there. I think that is inconsistent with the rules of the pet parade.
Hold on a minute.
What?
Bassie, come.
Even Bassie got an award for most lively. And if you know this dog,
come here. Come here. Over here.
Come on up, Bassie.
Come on.
Come
up.
on.
Come on.
Oh.
Come on. Here.
Oh.
Did you get an award yesterday?
She got the award for most
Come
lively.
Here. Come here. Come here. Look at everybody. Come
Okay,
here.
she's not going to listen. Stop. And then Lady got the award for most likely to lead the parade. But more to the point, Saturday we hope to show video of the, you know, the guns and
cannon?
the cannon, and you know, all the ceremony about the 13 original states, and it really was an awesome ceremony up on the Litchfield Green yesterday.
How'd the dogs handle the boom boom booming?
Well,
she's here.
Daisy did not appreciate it.
She's made her appearance.
You know, she may, and you can actually see her against the backdrop of your white shirt. Sometimes in pictures,
Look,
she melts into the background.
You have to look at everybody.
Oh, she didn't get a lower third. Only we got a lower third.
Oh. Okay, get down. Go on, get down.
Hey, but Master Control, Dan, was up there doing the videography yesterday, and he had an interesting point this morning. He said that there were a lot of people on the Litchfield Green openly carrying yesterday. I mean, there were cannons, there were long guns, they were actually shooting them off, and there were children around and pets and people everywhere, and nobody seemed concerned about it.
Nobody panicked?
Nobody panicked. Nobody was annoyed or alarmed. Well, some of the dogs were maybe annoyed or alarmed, but that was an interesting point. So why don't you talk about something, Ed? Because
well, I'm going to talk about something.
I'm looking at a response by our State Freedom of Information Act to a complaint that you filed saying that your case is not even worthy of a hearing, and in fact, it would be an injustice for your case to even be heard by the Freedom of Information Commission, because it would, in their words, set their schedule behind hundreds of cases. And I'm wondering, how long do they think hearing your case was going to last? 90 minutes. So I don't understand how hearing your case would set them behind hundreds of cases, unless, and I'm trying to think how they could rationalize that statement. So if your case is heard for 90 minutes, that means the next case is delayed being heard for at least 90 minutes, and the case after that for 90 minutes. So really, if you think about it, if they hear your case, every case in the future will be delayed, and you'll be responsible for it. So that's what I'm going through.
This must be a new aspect.
The above captioned appeal shall not be scheduled for hearing without leave of the commission, on the ground that there is reason to believe that such appeal would perpetuate an injustice pursuant to, and then they cite a statute, and would constitute an abuse of the commission's administrative process. Hearing your complaint would be an injustice and an abuse of the Commission's administrative process. I got to tell you, the Freedom of Information Commission has a lot of gall to say a statement like that. This is a commission that supposedly, markets in the free exchange of information, and on their public website, they had the law wrong. Say how they got the law wrong, Ed.
They had that you had to request access to documents in writing, and it was wrong.
And you pointed it out.
And judicial relied upon it and cited it at a hearing, and then the FOI had to change their website.
I think this is retaliation for you pointing out that the FOI can't even interpret the law properly on its website that people rely on.
The Freedom of Information Commission, in its day in the 70s, post-Watergate, served the public purpose. The only purpose the Freedom of Information Commission serves today in the state of Connecticut is to employ state workers to get paychecks, pensions, and benefits. That's all it is. Because here's the problem. The law clearly says, and the case law clearly says, a person can walk into a public agency and verbally ask to access a document to inspect it. You don't have to put it in writing. And it says that the public agency shall provide that requested access promptly. Promptly being, well, it could take a little bit longer. There could be reasons why they can't do it while you're standing there. That's fine. If you want a copy of a document, the public agency has the right to require you to put your request in writing, and then they have 5 days to respond to you. And if they don't respond to you within 5 days, it gives you standing to file a complaint. Now, in the city of Torrington, they didn't want to provide prompt access, wanted to require in writing a request for prompt access. And
which at that time you can't blame them, because if they would have gone to the FOI's website, it would have told them that that's fine.
But it's even worse than that. The Freedom of Information Commission has given lessons, seminars, classes to public officials throughout the state of Connecticut. And the FOI is now 32 years old?
I don't know.
76, 75 to, about 32 years old. And they still have not taught the public agencies correctly. I went to a seminar for FOI. I attended it. There were city clerks and mayors and members of the public agencies from all over the state of Connecticut. And the FOI presenter stood up there and actually said, you have to make the request in writing. After the seminar, I said, why are you teaching these people that when I walk in and that's what they say to me, it ends up in a complaint? Now, when did I make my request to Torrington?
I don't know.
Well, it wasn't within the last year.
It wasn't. Listen, it says the executive director is not seeking to schedule a hearing in this matter, but rather is asking the commission to affirm her decision not to schedule a hearing.
She's asking the commission to not schedule my hearing.
The executive director's decision not to schedule a hearing was based on the following factors.
Go ahead.
Here we go. A, the commission's resources are diminished due to budget cuts and consolidation with other state agencies. While its caseload has increased dramatically, it is impossible for the commission to schedule a hearing for every case that is filed. Okay, put that in writing, and now every state and municipal agency throughout Connecticut knows not only if it doesn't abide by the FOI laws, will there not be a hearing for an extended period of time, making people suffer, but now they also know that all they have to do is write a letter and maybe there won't be any hearing at all.
Right. Now, let me ask a question. When is the commission going to hear this?
You know, you ask me these questions that require me to go through and research. I mean, you know, you can't do it while we're on the air. Let me just keep going through it. We'll get to it.
July 12th.
Okay.
The commission shall consider whether or not to affirm the decision on July 12th at 2 p.m.
We got a lot of work to do before July 12th at 2 p.m.
Trust me, I can make a presentation off the cuff.
Okay, B. Now they talk bad about you in here, by the way.
Oh,
They make you seem like a crazy person running around City Hall bothering everybody trying to get information. The complaint in this matter, which was sent by email to the commission at 12:22 p.m. on August 15th, 2016. That's almost a year.
Okay, go ahead.
Alleges that the complainant visited Torrington City Hall at approximately 9:35 a.m. that morning.
Right.
And requested to inspect the following voluminous records, it says.
Voluminous.
That's like when you're talking about firearms, they call it an arsenal instead of a collection. You just throw in that word.
But they don't say what the records are.
They do. I got to keep reading.
Okay, go ahead.
In preparation for a scheduled public hearing later that night. It was a whole tax issue, right?
It was that people who had had overpaid taxes. If it was an overpayment of less than $5, the city of Torrington was just going to keep the money. They weren't going to give it back because it cost too much to give back the overage.
Well, that's what they said.
Go ahead.
Okay, so this is what you requested. Number one, all computer database information in a workable spreadsheet which specifically identifies all taxpayers who have paid excess amount on tax bills since July 1st, 2014. I would think they would have had that already in preparation for the town meeting that night.
In order for the tax collector to make a presentation at a public hearing, she's going to have to know how many people have overpaid, the total amount of the overpayment, and then get into explaining. And when someone overpays a government agency, do you not flag that section of the payment records and be able to extract that information and say these are the people that overpaid?
Okay, we're gonna have to go to the original documents for this next one. Number two, again, these are things that Ed requested. All written documents, including notes, letters, and emails regarding the retention and forfeiture of excess tax payments which are less than $500. I got to tell you, we got to check, but I
think a copy of my request is in there.
Here, you look at that part for that. Okay. Number three, the current statement from the account where any coverage of tax payments are deposited. Again, all these things would have been ready for the meeting.
Right.
Number four, all written or electronic notices which had been sent to individuals who paid excess funds towards their tax obligations since July 1st, 2014. Number five, all written legal opinions, local ordinances, statutes, or regulations which permit a delay in refunding overpayments to taxpayers. And six, any and all written correspondence with taxpayers regarding the retention of overpayments of taxes in the city since July 1st, 2014. Now, under FOI, even if they don't have everything you're requesting, what they do have, what they can promptly access, they still need to give you, right?
Right.
So I would think that a lot of this stuff would have been prepared for that night. And you know what you often do is you ask for this stuff because you want to be all-inclusive. They give you what they have, and most of the time you're satisfied with it.
No. The standard boilerplate response from a public agency is, you haven't properly described what you want.
Right.
Or we don't have what you're looking for. It's not in the file cabinet A, it's in file cabinet B. So you have to ask for all of the file contents of all the file cabinets, because if you ask for the wrong file cabinet or the wrong drawer, then you're screwed. Now, but listen to what this says.
Okay.
The city of Torrington says, okay, It is my understanding that the tax collector, Luna Galassi, provided Mr. Peruta with the documents he requested within a 24-hour period. Fine. I asked for it at 9 o'clock in the morning. For a public hearing 9 hours later at 6 o'clock at night. If you give me the information after the public hearing, what good is it?
And the way we learned about it was in the newspaper that morning.
And the newspaper may have made the mistake $500 when it was $5. But that's neither here nor there. They refused to even act on a verbal request for prompt access.
Did you find your request in here? Did you find your request? Weren't you going to look for your request? Okay. Okay, so we're still the reasons why they shouldn't have a hearing. So A said the commission's resources are limited, and B described what Ed had asked for. Now we're on to number C. The complainant alleges, oh, you got to hear this. The complainant alleges that upon receipt of this request, the respondent tax collector incorrectly informed him that she could not provide access by the end of business on August 15th, and further that she had 4 business days in which to acknowledge and respond to the request.
Right. And that is taught by the FOI. That has been the mantra of the FOI.
So prompt access is 4 days.
A minimum of 4 days.
A minimum of 4 days.
The floor is 4 days.
Prompt access is a minimum of 4 days.
The Freedom of Information Commission.
So if I walk into the town clerk's office and I can see the minutes, or the city clerk's office in Hartford, and I can see the minutes sitting right there in their file cabinet over there because it's open. Somebody left it open, let's say in this hypothetical, for the Police Civilian Review Board, and I can see them. Can the clerk look at me and say, I have 4 days? Is that what they're saying?
And my response in any government agency is, for prompt access, no, you do not. For prompt access, no, you do not.
Because what's the difference between prompt access and asking for a copy then?
One of two things happened here. Either the city of Torrington researched and came up with their own opinion on the 4-day, 5-day rule,
and God knows,
or they relied upon information provided to them by the Freedom of Information
and
Commission.
God knows this is the same city that about 8 or 9 years ago we had to point out to them that you can't charge daily fees for impounding somebody's motor vehicle on city property. And I went to City Hall and talked to the same clerk that's still the same clerk there, who seemed to just say, well, that's the way we've always done it. I said, I've researched the law. I've written you letters. You have no basis for basically extorting money from people and taking fees from them for impounding their cars on city property. And you know what? They stopped the practice.
Hold on. This is the same city
but did they
that was trying
people?
to charge $25 for a CD of public information. And we had to bring it to their attention.
You know what, Ed?
And they went down to $1.
You know what, Ed? I'm hot about this because we have allowed ourselves to become involved in the city of Hartford, and we have ignored Torrington for too long. It's getting out of hand.
Hold on, let me just do something.
The complainant also alleges that he proceeded to the mayor's office at approximately 9:50 a.m. and finding her not in the office, left a duplicate copy of his request, and then continued on to the Office of Corporation Counsel on the issue of prompt access to inspect public records, and engaged in discussions with various public officials over the issue of the 4-day rule. The complainant seeks the maximum civil penalties of $1,000 in this matter. To date, the commission has not further heard from the complainant on this matter. What were you supposed to say? Were you supposed to keep right? What does that mean? Once you file a complaint with the commission, are you supposed to keep in contact?
They want you to negotiate with the ombudsman to resolve the issue.
So is that retaliation because you refuse to participate?
I'm going on the 12th.
What are you supposed to do after you file a complaint with the commission? Are you supposed to write them every week, every month? Is there a rule about this? They hold that against you?
Here's the question. Are we a country of laws? And should the public be able to read and understand the laws, or case precedent going back to 1975, and expect the public agency to respond accordingly?
Oh boy, we're not going to get through all this. D. Okay, on September 12th, 2016, the Commission received a letter dated September 8th, 2016 from the respondents in which they informed the Commission that the complainant arrived at City Hall at 9:30 a.m. on August 15th and requested access to their database. Oh, okay, so we've already heard your side of the story. Now we're going to hear Torrington's side of the story. The respondents informed the complainant that they did not have a public computer terminal, were shorthanded, would respond to him within 4 business days, and that much information was available online. The respondents also informed the Commission that the complainant immediately called his lawyer and the Commission and proceeded up to the mayor's office. Finally, the respondents informed the Commission that they provided the complainant with some requested records later in the day within 24 hours. Okay, wait a second. So you were up there in the morning and they provided you documents later in the day, which would be within 24 hours. Okay, I get it. E, by letter dated September 15th and filed September 19th, 2016, the respondents requested that this matter not be scheduled for a hearing, indicating that the request was acknowledged on August 15th and that ultimately all voluminous records were provided to the complainant by September 8th. Now, we are busy, and we do a lot of different things. We could have missed that letter. I have a feeling, I'm not even going to comment. I'm going to do my due diligence. I want to see that letter. Was it copied? I don't remember that letter. It doesn't show it was copied to us.
Right.
So Mr. Hennick received a letter on September 15th, 2016 from the city of Torrington asking that there not be a hearing. How many months ago was that? 9?
Because I've been on Tom Hennick's ass.
And Tom Hennick did not call us up and give us an opportunity to respond to the letter from the city of Torrington. I can see, you know what? I can see how this phone call went. This is what's in writing. But I can see how a phone call went between the city of Torrington and Mr. Hennick. Hey, Mr. Hennick, we got this guy, Ed Peruta, and his lawyer, Rachel Baird.
Send me a letter.
You know, and you know, he's bothersome. He asks a lot of questions all the time, and Tom Hennick's like, oh yeah, we've had to deal with him for ages. You know, he's always filing FOI complaints all over the state, and we get what you mean. You know, we know what we're dealing with here. And Tom Hennick, well, send me something in writing. Send me something in writing. Be sure and don't send it to that lawyer, Rachel Baird, because God knows she'll respond to it. And don't let Ed Peruta know about it. Just send me a letter, and you know, in September, and we'll fix it with the commit. We'll fix it. And all of a sudden, we'll you know, write a letter to the commission saying we're not going to have a hearing. That's what we'll do. And you know what? We'll start doing that with a lot of people like Ed Peruta. People like Ed Peruta that ask too many questions. This is our new little thing that we're going to do.
New precedent.
Here. This is our new precedent. This is how we're going to deal with people. You know, how ironic is it, and I know that word is so overused, that Tom Hennick, what position does he have?
He is their training officer.
That Tom Hennick, the training officer for the Freedom of Information Commission, is soliciting letters from municipalities to him and not letting complainants know about them. Talk about lack of transparency. Mr. Hennick and the city of Torrington communicated behind your back 8 months ago to plot and scheme not to provide you a hearing, and you are just learning about it now?
Well, here's my question.
I got a problem
Here's
with
my
that.
question. Why is this being presented to the full commission to not schedule a hearing in July of 2017 when it could have been put on an agenda in October, November, or December of 2016?
You know why? Because this is what government does. They drag things out hoping that you've forgotten, that you've moved on to other things, and that you're not hot about the issue anymore. They kind of let it lay low for a while, hoping it just goes away. Listen, since September 2016, when the city of Torrington wrote this letter and plotted and schemed with Tom Hennick not to give you a hearing, you've had cancer surgery, you've been in the ICU for heart stuff, and you've been back to the Hartford Hospital. You've had basically 3 visits to emergency rooms.
Major medical events.
For major medical events. They're hoping you freaking die before it comes
hold
up.
on a minute. Hold on a minute. Let me tell you something. You've heard me say regarding the Peruta v. California that I like to make lemonade out of lemons. I have always asked, does the Freedom of Information Commission during their meeting have a section of their agenda where the meeting is open to the public so that the public can make comments? And they have said to me, well, you're going to have to ask if you can talk to them. Well, this right here gives me my opportunity to make lemonade out of lemons on the official record of the Freedom of Information Commission and tell them that as far as I'm concerned, they should be put to bed.
Oh,
they should be sunsetted.
Can we go longer? Does Master Control mind if we go a little longer? Okay, listen to this. Number F. Okay, E. By letter dated September 15th. Oh, we already got into that, where we didn't get this letter in September between the city of Torrington and Tom Hennick. Okay, F. The gravamen of this complaint is the complainant's apparent belief that requests for inspection of public records under the FOI Act necessitate a different standard of promptness than requests for copies of public records.
Absolutely.
That issue is squarely raised in another of the complainant's complaints filed with the Commission, Edward Peruta v. James Rovella. That matter is scheduled to be heard on July 11th. There is no need to adjudicate this issue twice. Wait a second. When did you file that? What number is this? This is, the Torrington is 580 and the Rovella is 613.
Did we ever go to a hearing on Rovella?
Well, it's scheduled for July 11th, so I guess we will.
Is that the hearing in front of a hearing officer?
Yeah.
What's going on?
What do you mean, what's going on?
I don't ever remember being there with the Hartford PD.
No, we're going to go. No, we're going to go next week, July 11th. We're going to go. We haven't done it yet.
Well, okay, right.
That's the one on the parking issue, right? On the ticket issue?
I don't know.
No, it is. It is. I'm telling you. Isn't that? Remember, you got that ticket?
Right. I don't know.
You do know. Stop it. Okay, so that's interesting, though. They're saying that they're going to adjudicate it at the other hearing. So does that mean that they don't know? Does that mean the FOI doesn't know? Is this an issue
they're
of first
claiming
impression?
that my belief is incorrect. That prompt access to public records to inspect is a different standard than at requesting copies.
Well, they're not coming right out and saying that.
Okay. It's 7:29. We can end it.
Okay,
we can pick it up. We can end it.
We'll
we
be
can
back
end
tomorrow.
it. You know, this is going to start a whole fucking thing today. You know, this is going to be crazy. But I'm looking to go after the FOI.
I got this like a week ago and I didn't tell you about it, so I knew it would.
See you tomorrow morning.
Bye.